on behalf of the 23rd respondent.
Excuse me, we have a procedure which we are following. Your Honor, allow me to rise and oppose this application and consider the same as a hopeless one that does not deserve the ink and the paper it's written on. Your Honor, the application is inviting you to limit the rights under Article 37. It has become a practice and the culture of the prosecution and the police when they want to suppress individuals who are fighting for freedom, like these freedom fighters, to bring such kind of applications. At the fullness of time, Your Honor, when considering this application, you might have to ask yourself, if the police finds that the suspects committed no offense, what shall follow therein after, if we incarcerate them for 14 days? Who shall be held responsible for that breach? You might also want to consider, Your Honor, whether the facts pleaded in these affidavits and on the face of the application convinces you to admit the application. For example, you are being told, Your Honor, that you incarcerate them because the police want to investigate the content of their phones, which they unlawfully confiscated. One, they admit that they have the phones, and therefore they're not in custody of the suspects. How will the incarceration assist the police to achieve the provisions or what is pleaded under paragraph 4 of the affidavit? Number 2, Your Honor, paragraph 5 tells you that you need to incarcerate them so that the police can investigate the CCTV footages for a nearby Java and Naivas supermarket. Are they in control of the suspects? Are they within the reach of the suspects? Will the suspects inhibit the police investigations and or access to those purported CCTVs? Therefore, if the answer to the court is to admit the application, how will that assist the police? Noting that our clients are not in possession of those CCTVs. They do not even know them. Their location is not even specifically pleaded. We are told they are near Java. Which Java? Near Naivas supermarket. Which Naivas supermarket? And there are several. And who is in the custody of these CCTVs? Are they private CCTVs? Are they public CCTVs? And how will the suspects interfere with that process? Number 6, Your Honor, paragraph 6 tells you that they need to record witness statements. This action complained of happened in the glare of the public on the streets of Nairobi. People were coming from Kayole, Mathare, Kileleshwa, and all over the. Some of them even came from Kirinyaga like myself, and I witnessed. So which witness is this? Who is supposed to record? We have 56 million Kenyans. We all witness this. Are we all possible witnesses before you that you all need to record statements? If that's so, Your Honor, I am ready to do one. Number 7, Your Honor, is even more ridiculous and annoying. You're being told to incarcerate them because, and I want to read in verbatim, that the respondents, if released, may continue to disrupt peace and tranquility. You incarcerate them on speculative and on mere speculation that they can interfere. These guys are being told, Your Honor, that incarcerate them because they may. Yani hawa watu wanaweza. You understand, Your Honor, the content of the contempt this application needs to be looked at? That is the contempt. That on mere speculation, you incarcerate them. Number 8, Your Honor, paragraph 8, the respondents are a threat to peace and stability of the country as they continuously incite If the police has evidence of continuous incitements, why have they not charged them on those previous alleged incitements? Members of the public via social media platforms, if released, therefore, they will cause disharmony in the country. Disharmony in the country. You know, what disharmony? The country is already in disharmony. And the mere fact that we have come here to defend these freedom fighters indicates and signifies the discontentment Kenyans have. So who is this complainant that his country has been disharmonized? Ni nani ana complain? So, Your Honor, you're being told at paragraph 9 that for interest of justice, I pray that this honorable court to grant 14 days. 14 days, Your Honor, to investigate speculations. 14 days to investigate content that are not within the possession of our clients. Your Honor, as I sum up, I want to invite you to have a look at the judgment in the case of, in the miscellaneous application E014 of 2023, Haji versus Republic. Of most interest is paragraph 10 of that judgment. The judge in that case said, the presumption of innocence also means that the pretrial detention should not constitute punishment. Because at the fullness of time, the event that the police reaches a conclusion that is no, our clients are not culpable, they have already have suffered 14 days incarceration. Finally, Your Honor, this is a hopeless application. In the event you find it worth not to dismiss the application, admit them on bail. The prosecution has already admitted that fact and even proposed stringent measures being proposed as against our clients. That's an admission already. So there is no opposition of our bail. It came from the prosecution. It's on record. So in the event, Your Honor, you consider it worth to admit the application and consider the proposal by the prosecution, admit them on free bond. Consider these individuals as freedom fighters. People who are fighting to liberate themselves from bad governance, from a government that does not want to be called to account, from a government that has transgressed over our constitution, from a government that listens not, from a government that has gone wrong. I invite Mr. Moro to submit.
Your Honor.